Summary judgment is an order made by a court in civil proceedings, normally following an application by a party to the litigation. It gives a final resolution to the dispute without incurring the time and expense involved in proceeding to a full trial. The court may grant summary judgment if it considers that the claimant has no real prospect of succeeding with the claim he's brought, or the defendant has no real prospect of successfully defending the claim, and there is no other reason why the case or issue should be decided by a trial. Summary judgment may be given upon the whole case or just certain specific issues in the case. The court can also decide to grant summary judgment of its own motion when neither party has applied for it. When may the court grant summary judgment? It is not always easy to succeed on an application for summary judgment. The court must be satisfied that the claim or defence has no real prospect of success, and this is not always easy to prove. But where it is clear that either the claim or defence has no real prospect of succeeding, the court should order summary judgment. The court will interpret real as the opposite of fanciful and should not conduct a mini-trial to establish whether a summary disposal is appropriate. If there are issues in dispute which are relevant to the success or failure of the case, which can only be determined by hearing the evidence, then a court is very unlikely to award summary judgment. Basically, the claim or defence must have realistic prospects of success. How do you apply for summary judgment? Firstly, whether you are a claimant or defendant, you should contact a solicitor as soon as possible to seek advice on whether your case is suitable for an application for summary judgment. Unless the court gives permission, a claimant cannot apply for summary judgment until the defendant has filed at court an acknowledgement of service or a defence. However, a defendant can apply for summary judgment at any time, although in both instances the parties must apply without delay. So you'll need to file at court an application notice in a particular form along with a witness statement in support of the application. That statement should set out the reasons why you believe summary judgment should be given. The respondent to the application must be given at least 14 days notice of the date fixed for the hearing, and the respondent should file any written evidence they wish to rely on at least 7 days before the hearing. An applicant who wishes to rely on written evidence in reply to the respondent's submissions must file this at least 3 days before the hearing. So, what are the possible outcomes from an application for summary judgment? If the court agrees that the claim or defence has no real prospects of succeeding at trial and there is no other compelling reason for a trial, it will, in the case of a claimant's application, award judgment on the claim, or in the case of a defendant's application, strike out or dismiss the claim. An application for summary judgment can be a useful strategic tool in a litigator's armoury. It can see an end to a dispute quickly. Even if the court is not prepared to give summary judgment, it may order the other party to replead its case, in which case that party is likely to be ordered to pay the costs of the application. This tactic can often bring the issues to a head more swiftly and more cheaply than simply proceeding to a trial, and can put pressure on the opponent to settle the case on favourable terms. So, in conclusion, I would recommend that whenever you receive a claim or a defence to a claim you have brought, you immediately consider with your solicitor whether an application for summary judgment is appropriate.